Now I will call forward the attorneys in 123005, Kansas versus Taylor. You're settled and ready. You can may approach and begin.
May it please the court, Caroline Zuschek, Deputy Capital Appellate Defender, appearing on behalf of Mr. Edroy Taylor. A brief synopsis of how we ended up here today. Mr. Taylor was convicted of aggravated vehicular burglary and sentenced to 100 months prison and ordered to pay $1,954.36 in restitution at a rate of $15 per month to begin immediately while incarcerated. The sole issue on appeal is whether the method of repayment of $15 a month to begin immediately during incarceration is workable. The district
counsel, can I back you up just a little bit?
Certainly.
Do you agree that the burden of proof to prove unworkability was on your client?
Yes, absolutely. And that was one of the reasons the Court of Appeals affirmed the district court's decision imposing the $15 a month. It's our position that Mr. Taylor did prove unworkability. He, in response to questioning by the court, noted he had no car, no home, no assets, and he had some support obligations for minor children, though based on the answers in the record, it appears it wasn't an official child support order. And he was immediately going to begin incarceration.
What's your position concerning whether the district court can consider your client's unsworn statements at hearing, and whether or not it can be considered as evidence?
Yes and yes. First, the district court considers unsworn statements by the clients all the time. In fact, some of these statements were solicited by the court to determine whether it would be appropriate to impose costs and fees. And if the judge can consider it for that purpose, where the statute requires the court to take into consideration those things.
Didn't that even happen in this case, that the district court made an inquiry about attorney's fees and costs and made a determination?
Yeah, at the original sentencing hearing, the judge asked Mr. Taylor, like, what are your assets? And he basically gave a few answers.
And was that in the form of unsworn testimony? I mean, it was.
He was not sworn.
An interaction from the district court to where.
Right, there was,
defendant.
yeah, he wasn't on the stand. It was just an sort of off the cuff discussion, which.
And is that the same thing that happened in the restitution determination? Also, the inquiry was made from the bench to your client.
That's my understanding.
Defendant's table. Okay.
Yes. And it's typically how those things are done. I don't think I've ever seen the court swear in an accused before determining costs and fees or attorney's fees. The court asks from the bench, and the presumption, of course, is that the person is going to reply truthfully. And I've never seen the state argue that that wasn't sufficient evidence to support a determination of costs and fees or attorney's fees. And so if it can be considered for that purpose, I find it hard to believe it couldn't be considered for this very parallel, similar purpose.
Well, the Court of Appeals said it really can't. So what is your authority to say it can and should be?
Well, the authority would just be that it is considered in similar situations. I don't think there's a case on point that says it can be. I don't think that there's a case that says it absolutely can't be. Obviously, the better practice probably would have been to swear him in, but I think we're talking about a technicality when that evidence is being considered in the same case for other determinations which require an evidentiary basis.
Clearly, he has a statutory basis to allocution.
Right.
So is there a difference?
I'm not sure. Like,
Well, is there a difference between the legality of the sentence and whether or not it should be imposed, which is clearly set out in the allocution statute, and those things that he testified to about restitution? Or is it all considered something that falls within the allocution statute?
I would argue it all falls within the allocution statute because yeah, part of the sentence is the restitution, as well as costs and fees, and the court has the authority to allocate that. And based on the answers to the questions, it's obvious that Mr. Taylor did not have sufficient resources to pay even the de minimis $15 a month. And in fact, this court can take judicial notice of the fact that he was sentenced on June 10th, 2020, and the motion to reconsider was June 11th of 2020 during the middle of the pandemic. And in fact, work was not happening in the county jail and in some prison facilities as well. So he indeed was not able to begin to make any sort of payments, and the plan ordered by the district court set him up for failure from the get-go.
Could you tell me your strongest argument as to what the evidence was about his ability to pay day after sentencing in the future? What he would have in the future, what he would be able to make in the future while he was incarcerated?
The strongest evidence would probably be the IMPPs that were cited in the record on appeal, and which are common knowledge to, I would assume, most district court judges, which is that the average wage per day is 45 cents to $1.05.
Was that presented to the district court?
It was not.
So it's not part of the record before the district court.
It was not part of the record before the district court, but I would argue that it's common knowledge. And it's also something, I mean, it's the policies and laws of the state. I can't imagine that district court judges sending as many people as they do into custody aren't aware of the limited financial opportunities defendants have while incarcerated.
Was the judge requested to take judicial notice of that common knowledge?
It wasn't, but it doesn't have to be requested. The court may under, I'm sorry, let me pull up the rest of the judicial notice statute, which is, sorry, 6409B. It may be taken without request of the party. If it's the duly published regulations of government subdivisions or agencies of the state. We would argue this is a duly published regulation of the Department of Corrections. Obviously, it's not the KAR, but it is of indisputable accuracy. It's readily available, and there's really no dispute that that's what the daily wages are.
Practically speaking, what happens to your client if he does not pay $15 a month?
Well, it's, I would assume, already been sent to collections because we know that he couldn't make the payments.
And then what happens?
A 33% surcharge is added on to the total. And then it's not very clear right now what happens. Previously, it used to be converted to a civil judgment. Under the revised restitution statutes, it appears it can still be garnished from any paycheck or wages. And
How can it be garnished? I mean, is there a statute that says it?
yes. I cited this in a brief I just submitted. It's, I want to say like 161, 69. It's the
Even though
first-
it's not a civil judgment?
even though it's not a civil judgment, it can still be garnished.
And where does the 33% surcharge come from?
It comes from the fact that it's automatically referred to a collections agent within 60 days of non-payment, and the collection agent is authorized to collect up to a 33%.
And that's through
surcharge.
the district, like the contract that the district court has with who's
Yes.
it's the court that's the entity doing the collecting. I mean, even though it's contracted out,
Yes,
or is it DOC? Like who does that?
it is the court.
Okay.
Or the victim or an aggrieved party can also use the same collecting agents, but typically the court is the one who automatically refers it after 60 days. And I can provide those statutes in a 609 letter following argument. I should know them off the top of my head, but I can't remember the numbers. But yes, that is the process, and that is what happens after the amendments. So he was set up to fail here. Even though $15 a month sounds like a de minimis amount, it wasn't de minimis to him. There was another case at the Court of Appeals recently. Another panel decided the district court ordered another client of mine to pay $200 a month while incarcerated. And the Court of Appeals found that was obviously unworkable. The evidence about the IMPP was likewise presented for the first time on appeal, and the court took notice of it. And they noted that the problem wasn't that the 33% collection fee attaches, it's that it attaches without any opportunity for success. You can't get blood from a turnip. And in this case, Mr. Taylor's financial situation is a turnip. And for those reasons, we would ask this court to vacate the restitution order and remand it with directions to begin restitution repayment either at a lower amount per month or upon his release from custody. And again, he's not contesting the total amount. He's happy to pay that. It's just the monthly payments are presently unworkable. And if this court has no further questions, I'll reserve the remainder of my time for rebuttal. Thank you so much.
It please the court, Assistant Solicitor General Michael Sarah appearing on behalf of the state appellee in this matter. Your Honor, it is the state's position that the burden of proof, as Justice Wilson's inquiry stated, to establish unworkability of a restitution plan or restitution in and of itself is on the movement.
So what should have happened here? I mean,
Evidence.
the district court clearly has evidence before he or she, I'm not sure who.
It was Judge Geyer.
Judge Geyer, that this individual is destitute. There's no money available to him, no resources. The state even suggests, well, he can ask his friends to pay it, which I don't see why that is even a consideration. But it's clear before the court that he's impoverished, no money's available, and that there's no evidence that he can make money while he's in prison. And if he does, it's going to probably exceed the $15 that's due. Why isn't that enough
Your Honor, I would
to show that the burden has been met and he's shown they waived attorney's fees and costs? That takes generally a consideration on the ability to pay. Why isn't what's before the court is demonstrated here?
Your Honor, I would disagree that evidence was presented. There were some unsworn statements of the defendant made.
I understand. So,
Yes.
so an inquiry like you and I are having, I don't gain any knowledge based upon that.
I think there's a difference in gaining knowledge and admitting evidence. I think the difference here is that the restitution statute, if you are claiming to be under the exception that either I don't owe or I can't pay, requires production of evidence. Statements to the court that are unsworn, this court has previously found in Holt, are not sufficient to establish that burden. I'm not.
So the rule is now that in any restitution hearing, if someone is claiming indigency and inability to pay, they have to get on the stand and prove that.
I think that they at least have to take the stand and give a sworn statement or provide an affidavit that is sworn. That is my read of the case law, yes.
Mr. Sarah, just to, not to interrupt you again,
Oh.
but I think everybody agrees the defendant has the burden to show it's unworkable. And in this case, he's proved, at the hearing, I'm currently broke. Would you agree with that? Currently.
Currently, and based on
Okay,
that-
it did without the issue about,
No, and
you know.
I base that, he actually didn't say anything in response to the court's question about restitution. His attorney did. And I would agree, she represented to the court that he had no money and no liquid assets at that point.
okay. And the district court says you're broke now, but perhaps you could make money or in prison or borrow money. Okay. Okay. So from your family or your friends, not borrow, but you could get money from your family or
That may
friends.
be a potential source of money, yes.
Right. Okay. So why isn't that pure speculation by the court? Why hasn't the defendant met the burden to show that he's broke and that nothing is going to change between today and tomorrow because he I just wrote, is it defendant's burden to respond to speculation by the court that he could make money in prison? Is he required to call an expert to testify as to whether a prisoner will secure employment? And if they do, how much money that prisoner will make?
Your Honor, part of the thing that I don't think the court is speculating on is, again, the defendant didn't produce any evidence below about his future earning
But
potential.
how is he supposed to do that?
Well, he does have the ability to work in prison and he chose not to present that evidence.
How do you know that? How do you know when
I
his
know that
ability-
as the defendant has put, as the defense counsel has pointed out, that is my common knowledge and my previous experience as a trial attorney. I can
So
only
you're
assume-
saying
I
that,
can only assume Judge Geyer knew that too, and it was suggested by the state in one of the motions that he had this
but
earnings
what's
potential.
that speculation? There are prisoners that can't work or that don't get a job, especially in the middle of a pandemic. So as Ms. Zeschek pointed out, he's ordered on June 10th to start paying immediately. June 11th through, I don't even know, maybe a year. I can't remember, exactly, but he's in county jail because they're not even sending people to prison. So clearly for that first whatever, he's not working because he's in the county jail and he doesn't have a job.
Again, all information I think should have been presented below. And was
How
not.
is he supposed to know he's not going to prison, that he's going to be kept in the jail?
He has the burden of proof to establish he is the exception to the rule, Your Honor. That is
But
where,
he doesn't know what's going to happen to him. He is not in charge of his life.
again, Your Honor, this would have been information that he should have presented to the court. The only thing that he presented to the court was, I have no money at this point and I'm going to prison.
And I have no idea what's going to happen to me
No.
starting tomorrow because I'm not in control of my life.
I actually never said that, Your Honor. He said there was never any statement by the defendant or counsel about, I don't know what's going to happen to me while I'm in
So
prison.
what would have satisfied under the burden shifting or the burden to prove unworkable? What evidence should he have presented?
He needed to present sufficient evidence of compelling circumstances to excuse requirement to pay restitution.
Give me an example
An example of what, Your Honor?
of unworkability in the future, because you
Unworkab-
already agreed that he already proved that
If he,
he's currently
and now I'm speculating, Your Honor, but possibilities would be if he had a physical infirmity, a mental infirmity, if, as you put it, if the pandemic had some effect on the workforce in the prison, something to indicate, and we've in previous, I'm sorry, Your Honor,
I don't know how he's supposed to know that on the day of his sentencing.
he's asking to be excused to pay $2,000, Your Honor. I think that it is on, the statute is very
No,
clear.
he's
the
not
burden-
asking to be, no.
He was being asked to excuse, to not have to pay that immediately. That was his request. Actually, his request at sentencing said restitution was completely unworkable at all. Didn't mention the payment plan. In his amended motion, he said, I'm willing to pay it, but please give me till the end of my sentence. So there are differing requests made at sentencing and the motion to amend.
But based on the evidence presented, don't you think it would have been much better if the court would have said this restitution order is made contingent upon employment in prison?
That is possible, and there's previous cases where that has happened, Your Honor, and it's been appealed, and it's, I can't remember if it was upheld or not. I'll be honest, most of our case law dealing with this issue usually has to do with, and the Holt case is a good example of restitution being ordered upon release. And there, they do say the defendant has the burden to come forward. If you don't want to pay it upon release, or if you want to be excused due to your financial circumstances, and Holt was a life sentence with a possibility of parole after a hard 25, I believe, that he had to come forward with evidence. And this court said at the sentencing hearing to show why he shouldn't have to pay when he's released. It said his unsworn statements that he was currently broke and couldn't predict the future was not enough. I
But the
believe-
law has changed since then, and that's not this case.
How so, Your Honor? To my view of the restitution statute, the unworkability provisions of the restitution act.
Right, I mean, that's true, but now you got to pay right away.
Not necessarily. I believe the statute currently says you get to either pay it immediately or upon order of the court. And if it is, and again, the order of the court to pay upon release, that's not necessarily even binding on the parole board when somebody's released on post release.
Exactly.
That's the Eubanks case, says that it's a suggestion. And interestingly, the burden when they get out on post release is the same here on workability. They still have, if they want to establish unworkability to be excused in paying restitution or at a reduced rate, they have to establish that to the parole board.
What's our standard of review here? Is it a negative factual finding essentially that there was not, or there was an absence of a finding of a compelling circumstance?
Abuse of discretion, Your Honor. That is, that no reasonable person would have taken the position by the district court, mistake of law or mistake of fact.
And then, okay, under the abuse of discretion standard, how do we evaluate the absence of a finding? just essentially still abuse of discretion, or is there any guidance beyond that that directs our review?
Not a ton, Your Honor, at least from my review of it. Essentially, the burden of proof placed on a defendant in this kind of situation being when he is asking to be excused from paying or paying at a reduced rate is to prove a negative.
And the district court in its ruling addresses the arguments that were raised by the defendant in terms of the workability. Is that correct?
It is, Your Honor.
Is
and indigency, yes, sir. In the written order issued by Judge Geyer, he said that he considered the current status of the defendant as an indigent person, also taking into account his future ability to pay, and said there was nothing in the record to indicate that he would not be able to earn a limited income while in prison.
So are you talking about, counsel, then that it would be up to the defendant who knows the defendant's situation, future situation, to address the court or bring testimony from witnesses or documents that say, for example, I do not expect to inherit anything while I'm in prison. I don't expect to be able to, this is proof of how much people can earn in prison. Other people have earned in prison, and those kinds of things. Are those the things that he has to bring forward?
I believe that is the state of our current case law, yes, Your Honor. The Heron case, which is cited by the defendant in his brief and relied upon, where unworkability was found, there was extensive testimony presented about the financial burdens placed on the defendant in that case, which would have been prohibitive to her paying restitution, particularly in the amount ordered, as I recall. Every case I found where unworkability has been determined, there has always been evidence by way of either testimony from other witnesses or by the defendant themselves.
You mentioned that he had children. One possible piece of evidence might be a court order for child support, future child support, correct?
Yes, Your Honor. That honestly, had I been defense counsel, I may have presented that as if I was trying to get a restitution excuse.
Well, aside from that, he did say that he had children.
He said he had children. He said he pays their mother to take care of them. But then also when Judge Geyer asked, again, this was on the attorney's fees issue, if he paid to support them, he advised, no, he did not.
So we know that he's indigent today. We know that he has children. Can we use that statement as something for the court to consider as evidence, as a legal obligation for him in the future during his incarceration?
If it had been presented as evidence, possibly.
Well, he said it.
And Your Honor, my read of our case law on this particular issue and his burden of proof doesn't, simply saying it and not being sworn to it is insufficient as evidence.
So does the answer then turn on that?
I believe it does, Your Honor.
So we're going to make them file an ineffective assistance of counsel claim. So it can come back up on that.
Well, Your Honor, my primary practice is ineffective assistance of counsel, and I'd say I've seen them filed for far less. And honestly, if evidence is required to be presented by statute, I think that is the obligation if you're asking to be excused. Now, whether counsel is ineffective or not in this particular situation, that's a matter for a different kind of post-conviction proceeding.
But he's
Yeah.
statutorily able to allocute
Yes, Your Honor.
as to the legality of a sentence. So at what point do his statements in this case to the judge depart from what he's statutorily entitled to do without being sworn? What requires, in your mind, cross-examination, being sworn and subject to cross-examination?
Your Honor, the allocution, the difference I see here is the allocution statute being allowing you to advise the court and address the court about your sentence and the legality thereof. The restitution and the workability provision don't have anything to do with the legality of the sentence. It's being asked, you're being asked to be excused from or pay at a reduced rate of a financial obligation incurred as a result of your conviction. So the argument, when you're asking, my difference is when you're allocating and talking about the sentence, when you're talking about workability is just asking for an excuse, some mercy based on a financial or other situation where you have evidence to support that, versus allocution where you are able to address the court, advise the court of your thoughts and feelings and requests for.
And ask the court for mercy
Ask the court for mercy, yes.
in allocation.
Yeah.
Allocution. Sorry. So you're in allocution when you're talking about the time of your sentence or, it within the border, within the box, going for the lower number. What's the difference between that and pleading for mercy and restitution and pleading for mercy?
I believe because this court has said restitution is the rule and unworkability is the exception, and evidence is required by statute to invoke the exception. Whereas requesting mercy through allocution or low box number, or, if you filed a motion for dispositional and or durational departure is fine. And I will say I've had clients that when I was a defense lawyer did testify at departure hearings.
Okay, what you're saying that restitution, to depart from the presumption of restitution, you have to have evidence?
That would be one way to put it, yes, Your Honor.
And is that a statute you're talking about?
Yes, the restitution statute and the case law requires the burden of proof to produce evidence of unworkability on the defendant requesting to be excused.
Counsel,
Yes, sir.
I'd like to spend at least a minute or two.
Like I don't want to eat into Mrs. Usek's time, Your Honor. And
I'll eat into it. I want to spend a minute or two setting aside the substantive legal questions about burden of proof and what counts as evidence and all of that. And just ask some practical questions.
Yes, Your Honor.
What happens if this $15 a month is not paid?
Your Honor, I am not as familiar with the civil garnishment
Well,
provisions.
do you dispute that this will go to collections and
I'm not.
interest and fees will be added on top of it?
That I'm not certain of.
So
In
when
light of
Sorry, go
the
ahead.
statute continues to say chapter 60, article 7 can be used to collect. And I will tell you, Your Honor, I'm getting notices on former cases where it is being used to garnish wages. I don't know if there are fees attached to that. I would assume there are, but I don't know that there are. And in wake of Robinson and the unconstitutionality findings, I'm not sure how the civil code continues to interact with the restitution statute, but that is how it is being litigated.
So when the defendant in this case filed his motion for a modification the day after
Yes, sir.
sentencing, the state filed a response, I think, is that correct? And I look at the district judge's ruling and I see the district judge talk about the state's objection to jurisdiction,
Yes, Your Honor.
but I don't see, or at least I haven't dug into the case enough, the record enough to know what the state's position was on the request to reduce restitution. Did the state take a position?
The state objected to the reduction, advised that their position was that the defendant had not produced evidence
Okay,
that his future income.
so this goes to my whole practical line of question.
Yes, sir.
And I'm reminded a little bit of the viral Allen Iverson clip about practice. We're here about $15,
Yes, sir.
$15 a month. The state has insisted that this $15 needs to be paid.
Yes, sir.
We've had all of this time and judicial resources taken up over $15 a month. We're talking about collection and fees and interest being put on top of this individual when he's in jail. I just, is there a practical explanation for why the state over $15 a month?
As Your Honor, I'm sure is aware, this is case by case. And in this situation, someone who was badly hurt, $2,000 medical bills, there was a victim in this case. And the purpose of restitution by our case law is to not only rehabilitate the offender through payment of restitution, but to compensate the victim.
So is it fair to say that the state's position is that if we don't get this $15 a month, we won't get paid at all? I mean, because I will say I have some skepticism about that argument, but at least that would make sense to me.
I would doubt that would be the case. Your
Okay,
Honor.
so if that's not the case, then doesn't the whole, and I get that crimes have obviously have significant impact on victims, and restitution is a good and appropriate thing as set forth by our legislature. That all makes perfect sense. But what we're talking about here is the $15 a month while he's incarcerated,
Yes, Your Honor.
not the payment of restitution. So if you're conceding that, you're not saying that, hey, if we don't get this $15 starting right now, then the victim's never going to see any money.
I'm not conceding that, Your Honor, because
Oh, I thought you just did.
Standridge and I were having a lively discussion. I can't predict the future. I'm speculating on that as well. So no, I will not concede that we'll never see that money. We may never. Mr. Taylor, when he's released, may never work by choice or whatever.
Well, let me put it a different way. even if it's just purely a matter of tactics, it would strike me as more likely. I mean, if my goal is to get the most money out of this individual I can, would strike me as a better strategy to wait until he's out of prison and can work and then go after him.
And Your Honor, I will say this, in the cases where that has run workability based on payment in prison in our previous case law has been found, that has been the court's ruling. They vacate the payment plan, uphold the restitution, advise that the court's order that restitution be paid.
And that may not be available to us based on the legal precedents and statutes, and I get that. I'm just trying to, again, I think these cases have a really significant practical dimension to them. And if everyone's goal is to get the victim made whole, I'm struggling to see how this is the best way to do it.
Well, I think there were two things, and one of the things Judge Geyer put in his order and that the Court of Appeals noted, and I think their analysis is very apt. The offender reformation portion of the restitution, encouraging Mr. Taylor to work while in prison because that promotes offender reformation, provides him with skills, provides him with tools when he gets out. I think that's one component. The other is, Judge, or Your Honor, the fairness to the victim. How long should they have to wait before they receive compensation? 100 months, a life sentence? What is fair to them? Because there are balancing interests here. I think the state's position is it was not unfair to ask Mr. Taylor to pay $15 a month on a $2,000 medical bill on harm that he caused. Now, I don't think it's unfair. I think that's more than fair to the victim. The practical effect, I recognize, but practical effect sometimes has to give way to fairness to the victim and justice being done. Restitution is something that is required as a result of a conviction of this kind. I am well over time, Your Honors, unless someone has additional questions for me.
I guess I have one.
Yes, sir.
Wouldn't you agree the Court of Appeals overstated notion that unsworn testimony has no value during these hearings? Holt.
I don't know that they overstated it, Your Honor. I think they very strongly adhered to that precedent. I will get.
What they say is the Supreme Court in Holt, and I wrote Holt, held that because the defendant was not sworn as a witness, his so-called testimony about his financial statement. There was no holding that way. It was an observation on the way to a different point.
In which case, Your Honor, if there's dictum or in that case, it's unclear, I think that it should be cleared up because I tended to read Holt the same way the Court of Appeals did, and the precedent of this court is that if you want it to be considered as evidence and it is your burden of proof, you should be sworn and subject to cross-examination.
I think what it says is the defendant was overstating as testimony something that wasn't testimony. It doesn't say that you don't get to have these what are amount to very practical exchanges between parties during litigation with court. So
I'd agree, Your Honor, but I also think that in this particular situation where there is an evidentiary burden on the movement, that it's not unreasonable to request that they're going to present evidence that it be sworn.
Would also be reasonable to say perhaps the weight and credit given to what he says might be a little different without cross-examination than it would be with cross-examination.
I would agree with that, Your Honor.
Questions? Thank you, Mr.
Thank you, Your
Taylor.
Honor.
Reserve 2 minutes. I'm sorry, you reserved 3 minutes. I looked at the wrong place on my sheet.
Thank you, and may it please the court. To start out with, opposing counsel noted that there's an evidentiary burden on the accused to come forward with evidence of unworkability, and he characterized that burden as statutory. I acknowledge that the case law says that the burden to prove unworkability is on the accused. However, the statute 6604B1 doesn't say that the burden is on the accused. That's case law. And it also doesn't say that evidence is required to be presented. It merely says that the court, if it finds compelling circumstances, can depart from the order. So if we're looking at what the statute actually requires, I believe that what occurred in this case should be sufficient. There was a back and forth between the court and the accused. The evidence was put forward. I haven't heard the state dispute the accuracy of the evidence given. They're not alleging that he most likely holds secretly copious resources. If he did, the public defense system never could have been appointed. I mean, we already know that he's indigent, and in this case, his form of indigency simply wasn't part of the record, and I wasn't able to get a hold of it. So,
Your position then that if somebody is poor on the date of sentencing, that they should never have to pay restitution during incarceration, that it's
No, not at all.
simply as a matter of law?
no, not at all. In fact, I recently represented another client that was ordered to pay restitution while in prison at a rate of, I think it was 15% of her monthly income once she begins earning it. I think that's a completely fair and reasonable order. That way it's tied to the actual, once she actually earns money, she will be paying a part of it. And that ensures both that the victim gets immediately compensated and that she's not put in the untenable position of not being able to buy soap or shower shoes.
So it sounds like from what you just said, that you sort of answered the question I wanted to ask, but I want to make sure that you wouldn't actually take issue with what I understood the state's position to be when I sort of pressed in on the low dollar amount, that there's some measure of symbolic importance actually of some minimal payment, even while a defendant who's indigent is incarcerated.
Yeah. I think
So even if
that's-
it's like $5 or whatever.
I think that if the
You're not-
district court.
I'm sorry,
Yeah,
you're not
sorry.
taking an issue with that.
No. Sorry, I didn't mean to interrupt
No,
you.
that's okay. I appreciate the.
Yeah, no, I would agree that certainly there are certain amounts that could be ordered while a person is incarcerated that would be reasonable. I think tying it to the influx of income is a really smart way to do that. And I've seen since the statute changed in 2020 to have the default be that payments are due immediately to a lot more income tied orders. You know, once you get a job in prison, you should pay this much per month. And I think those are a lot more workable, or at least I don't have a good argument that they're not workable so long as there is actual income occurring.
But aren't you proving workability as opposed to unworkability? I mean, you're you're showing a plan that would clearly be workable, 15% of, but it's your burden to prove that it's unworkable.
Precedent by this court says it's my burden to prove that it's unworkable. And I think that showing that he wasn't able to work and had no money to make payments is evidence that it's unworkable. There's absolutely no way that he could have made these payments absent a job in prison. And as Justice Standridge noted, we can't be sure that he'd get a job in prison. Not everyone gets a job in prison. And based on his work history and what we know about him floating around Topeka and being younger, I think in his early 20s at the time of this, we can't assume that he would get one of the higher paying jobs. I mean, presumably he's going to be limited in the skills that he can perform at.
We really
So
can't assume anything, can we?
I think we can make those inferences based on what evidence is in the record.
Well, isn't that the point? We can't assume anything. So neither can the judge. No one can assume anything. What we have before us is he's broke. You know, it goes back to what I said before. He's broke. And the judge can't say, well, you'll probably get a job when you're in prison. And, you know, you can have your parents or your relatives or your friends give you money so you can make this restitution payment. You know, that's where the speculation comes in, and where you've proved this is where I am today. And I don't have, you know, there's no evidence here to show anything's going to change between today and tomorrow.
Exactly. And isn't that the point of a burden of proof?
Well, I think things have really shifted since Holt. So all of this is relating back to Holt, when the default, of course, was that restitution would be due upon release and determined by the parole board, when there would be another chance for the accused to get up and say, this isn't workable based on my current circumstances today. And so often those restitution orders were upheld despite, you know, sometimes extreme amounts, because a person couldn't prove some future thing that hadn't happened yet. And they would have an opportunity when those circumstances came due to show it again. But in 2020, the legislature amended it and said, the rule is now that restitution is due immediately unless otherwise specified in the court's plan. So this idea that you need to prove some future unworkability doesn't really hold true anymore, because that was based on this idea that, like, you needed to show that it would never be possible because there would be another opportunity to come before that board and show that it wouldn't be possible upon release. Now, we just have a statute that says the judge has to find compelling circumstances. And we also have imprisonment alone constituting a condition that can make certain repayment plans unworkable, unlike in Holt, because now that money, and in this case specifically, was due to be collected immediately. And I think that the court, the evidence in the record shows that he was going to be immediately incarcerated. I think that could be evidence of his present inability to pay. And he's not arguing he has a future inability to pay. So I don't see why there needs to be more of a burden to put on evidence of that. So I would argue that because of the change in the statute, making restitution due immediately, the type and quality of evidence that need to be presented are not as significant as they were, unless, of course, he was still trying to argue that this 1954-36 was inappropriate upon release. I would also just note quickly that he did answer the court's question. It wasn't his attorney. If you look at volume 5, pages 14 through 16, it's defendant Taylor responding that he doesn't have a job, he doesn't have a car, he doesn't have assets, a bank account with any money in it. And I would also, Justice Steagall, earlier, we were discussing what happens practically under House Bill 2608. The 2020 version of 216604B2 still permits wage garnishment, as opposing counsel noted, under Chapter 60, Article 7, and under KSA 2169, it's still assigned to the collections agents with the 33% surcharge. And with that, I realize I'm out of time.
Still would be subject to the prejudgment bonding requirements for garnishing something before judgment, correct?
I'm not totally clear on that. I apologize for that. I'm just not a practice at the trial court, so I need to understand it better than I do just by reading the statutes.
Questions? Thank you, Mrs.
Thank you so much for your time.
Thank you to both counsel. We will take this appeal under advisement.